Hi, I'm Don Havre of the real estate firm in the Tri-Cities in the state of Washington. Today we're going to be discussing the Seller Disclosure Report. This is part of a mini-series on the home buying process. Now, the intent of this particular video is to concentrate on residential purchases only. I will not be discussing land sales nor commercial properties. During the home purchase process, a buyer for improved residential real estate in Washington state is entitled to receive a seller disclosure statement. The disclosure is commonly referred to as Form 17 of the Washington State Real Estate Standardized Forms. Now, the content of the disclosure does change over the years with changes in the legislation, and real estate agents are required to furnish the most recent form to their selling clients who ultimately complete the form. Now, the form generally covers topics such as title, water, sewer, on-site sewage systems, structure, systems and fixtures, homeowners association, environmental issues, lead-based paint, manufactured and mobile homes if applicable, and other conditions or defects. The seller must deliver the disclosure within 5 days of mutual acceptance unless the seller is exempted. And there are certain situations where a seller could be exempted. Among these would be someone being a personal representative of an estate or possibly a bankruptcy trustee. I think it's fairly clear that if someone is representing a deceased person, they may have little to no knowledge of the property and therefore not be able to complete a property disclosure. A second item deals with someone who's had an interest in the property within the last 2 years. So let's say hypothetically someone owned a property, sold it, and within 24 months was purchasing the property back again. It's assumed that they would have some background information on that property. The third item deals with leases and life estates, situations that are less than fee simple. How about if we have a situation where we have a gift to the next of kin or a sale to the next of kin or possibly a divorce situation? In all of these cases, it is assumed that the purchaser or the new owner would have some background information on the property, so therefore these are exempted situations. New construction. Builders are given a partial exemption for new construction. Resale of foreclosures by banks is not exempted. Now, I would recommend that you always contact your attorney if you're in this foreclosure situation and get legal advice there. Buyers may waive the right to receive a seller disclosure except when any item in the environmental section is answered yes. So if the seller has completed the form and there's any item that's marked yes in the environmental section, you're required by law to receive that, that form, and you cannot waive the right. Once the seller disclosure is received by the buyer may rescind the offer up to 3 days following receipt. Now, think about this situation. What happens if an offer goes in, you think that this property is well suited for you, you review the seller disclosure, and upon reviewing the seller disclosure statement, you believe that there's some items in there that are just beyond what you can accept. Well, this law provides you 3 days to rescind the offer and get your earnest money back. Now, there are situations where the seller fails to deliver the form, even when required by law. And if this were to occur, the buyer retains the right of rescission up until closing and is entitled to return of all earnest money if the buyer rescinds. Think of a situation where maybe it was 90 days ago that a buyer puts an offer in on a property and it's accepted and it's going through escrow and the purchaser's at the closing table and starts thinking about that the property values have declined in that 90-day window, and let's say hypothetically the property is worth $15,000 less than what it was when the buyer initially purchased the property. Well, this would be an opportunity for the buyer to rescind the offer if they did not receive a property disclosure when it's required by law for one to be delivered. What happens if the condition of the property changes and it impacts upon a previously completed disclosure? In this particular case, the seller is required to amend the initial disclosure and to deliver an amended copy to the buyer. Upon receipt, the 3-day window starts all over again. Now, I'd like to remind you the intent of this video is to provide an overview of the Washington State Seller Disclosure Act only. If you'd like to have a copy of Form 17, you can do so by just sending me an email to don@key2homes.com. Once again, that's don@key2homes.com. and I'll return an electronic copy to you. I would like to also remind you that if you have questions about your legal rights to include information in this video, you should always consult your attorney. Well, once again, I'm Don Havre of the real estate firm in the Tri-Cities, and I do work with my daughter Michelle, and we're ready to assist you when the time is right for you.